We continue to discuss the changes to the new auto no-fault laws, and this week we take a look at the rights for medical providers. So Tom Sinas joining us to talk about their reinstated rights and what providers are again allowed to do. A lot of intricate details of this new law.
Yep, and you and I have had this ongoing project over the last few weeks to break down sections of this new law so that people understand how it affects them.
Okay.
And how it affects their medical providers, because of course that affects them as well.
For sure does.
Right? So I got to go back in time a little bit. Before 2017, a medical provider who treated an auto accident victim had what's called a statutory right, had a right under the law to sue a no-fault insurer if the provider's bill wasn't paid or wasn't paid in full. Simple enough, right? Well, in 2017, the Michigan Supreme Court handed down a decision in a case called Covenant Medical Center versus State Farm, and upended what was probably about 25 years of established case law, and held, for the first time, that medical providers did not have a statutory right to sue a no-fault insurer. So that, of course, changed everything for the last couple of years. And what happened for the public, particularly those in auto accidents, is that every time they were going to the doctor, and this will continue, they were being asked to sign what's called an assignment of benefits. And that means, let's say you're the doctor and I'm the patient. Every time I go see you, you ask me to sign a form where I assign to you my rights to go after the no-fault insurer. You didn't have to do that before 2017 because you could do it on your own. So what happened here back in June of this year? Massive overhaul of the no-fault law. One of the changes was to restore the ability of medical providers to sue a no-fault insurer directly. So let's say you're a hospital in Grand Rapids. Now you can sue in the name of the hospital against the no-fault insurer for the patient that you treated.
Interesting.
It's a little different. There's some changes to how it was before. But the other thing the public should know is that if you're treating for an auto accident injury, you're likely going to be continued to be asked to sign these assignment of benefits because the law sort of has to catch up with the facts, and I think that'll take about a year. Those assignment of benefits, they do seem like standard forms, and oftentimes they are, but they can also have serious repercussions for certain people in certain situations. So, you know, I know you're asked to sign a lot of forms, and my job is to tell you to read them and think about them.
I know. That's always the fine details and the fine print. They really got to pay attention. Where do people track you down if they have a question about this?
No problem. They can find us anywhere online, www.sinusdramus.com. Give us a call in West Michigan at 616-301-3333, or shoot us an email at info@sinusdramus.com.
All right, thanks, Tom.
Thanks, Derek.